Now look, I want you to sit with me for a minute because this one matters more than most people are letting on. You may have seen the headlines. You may have skimmed past them, thought to yourself, another court decision, another round of legal back and forth in a country that never seems to stop fighting with itself. And I understand that feeling. I have seen enough of these moments to know that legal news can feel distant, abstract, like something happening behind a velvet rope that does not touch your life. But I am here tonight to tell you that this one is different. This ruling, and I want you to hear me on this ruling is not just a legal story. It is a political story, a generational story, and depending on how the next several months unfold, it could be a story about the kind of country we hand to our children. Most people who saw the brief coverage did not realize what actually happened in that courtroom. They heard the word ruling and they moved on. But those of us who have been watching the courts for a long time, and I have been watching them a very long time, we know that some decisions echo for decades, and this is one of them. The surface of this reads like a narrow legal dispute, a procedural question about jurisdiction or standing or the scope of executive authority, the kind of thing that makes eyes glaze over at a dinner table. But if you look underneath it, and I mean really look, what you find is a redrawing of the lines, a change in who has power, who can be held accountable, and who gets to decide what the law actually means in this country. That is not a small thing. That is the whole game. And tonight, I want to walk you through exactly what happened, why it happened, and what it means for you, not in legalese, not in the language of cable news panels, but in plain language that respects your intelligence and your time. Now, here is something I want you to hold on to before we go any further. There is one part of this story, the piece that nobody in the mainstream coverage seems to be focused on, and I am going to come back to it before we close tonight, because that is the part that changes everything. I promise we will get there. But first, I need to build the picture. And there is a date coming on the calendar, a deadline buried inside the procedural schedule of a related case that most analysts are treating as a footnote that may matter more than the ruling itself. We will come back to that too, because when you hear it, you will understand why this story is not over. It is barely beginning. First, let us understand how we got here. To understand tonight, you have got to understand how we got here. Because the chain of events matters, and in this case, it stretches back further than most people realize. Every decision echoes for years. What we are watching right now is the echo of a philosophical battle that has been building quietly inside the American legal system for the better part of 3 decades. It began, as so many of these battles do, not with a bang, but with a series of small, incremental moves. Appointments to lower courts, shifts in how legal briefs were written, a gradual changing of the water that most people did not notice because the river looked the same on the surface. Federal judges were confirmed in large numbers over the past decade and a half. The ideological composition of the appellate courts shifted, not dramatically in any single year, but persistently, the way erosion reshapes a riverbank over seasons that each seem unremarkable until you step back and realize the landscape has changed entirely. The case that produced this ruling had been working its way through the system for years. It started, as these things often do, in a district court that most Americans have never heard of, in a jurisdiction that was selected, I would argue, with considerable care and deliberate intent. A challenge was filed, and here the legal details matter, so stay with me. A challenge to a specific regulatory action taken by a federal agency. The plaintiffs argued that the agency had overstepped its authority, that it had made a policy decision Congress never actually authorized it to make. The government responded that it had every right to act as it did, that the statute was clear enough to encompass the action taken. The district court ruled one way. The appellate court, in a divided opinion that drew significant attention from legal observers, ruled the other. And eventually, as it was always going to, the question arrived at the steps of the Supreme Court. Now, the Supreme Court had choices. They could have resolved this narrowly. They could have looked at the specific agency, the specific statute, the specific facts before them, and issued a tightly bound ruling that changed almost nothing for anybody outside of this one particular regulatory dispute. Courts do that all the time. They resolve an argument without setting a precedent that rewrites the broader rules. Sometimes that is exactly the right call. This court chose not to do that, and that choice, that deliberate, conscious decision to write broadly rather than narrowly, is the thing that most people missed entirely. The opinion runs long. The language is expansive in ways that go well beyond what the case strictly required. And buried in the majority's reasoning is a legal principle that has implications far beyond the dispute that brought the case to court. It touches environmental regulation, labor rules, financial oversight, food safety, drug approval, workplace safety standards, and a dozen other areas of American life where ordinary citizens rely on federal agencies to enforce protections that Congress wrote into law at some point in the past. That is not a small matter. That is the architecture of the modern regulatory state. And this ruling is a challenge to that architecture. Let me be precise because the details matter more than anybody's spin. The legal doctrine at the center of this ruling is one that has been debated in law schools and judicial chambers for years, but that rarely makes the front page of your newspaper or the chyron of your evening news. Essentially, the court has signaled, and in parts of the opinion stated with notable directness, that federal agencies cannot continue to act on broad, vague delegations of authority from Congress. When Congress passes a law that says, in effect, here is a general goal, agency, you figure out how to achieve it, the court is now saying clearly that is not sufficient. If Congress wants a federal agency to take a major regulatory action, one that affects large segments of the economy or significant numbers of Americans, Congress must say so specifically. It must grant that specific power and specific language. Ambiguity no longer resolves in the agency's favor the way it once did. This is a significant shift, and I want to be honest about the scale of it. For much of the 20th century, the courts generally deferred to agencies on questions within their technical expertise. The logic was reasonable and, at the time, widely accepted across the political spectrum. Congress passes general laws. Agencies are staffed with specialists who understand the technical details far better than legislators do. Let the specialists make the calibrated calls. That arrangement was never perfect, and it was always contested at the margins. But it functioned. It gave the regulatory state the flexibility it needed to respond to changing circumstances, to new technologies, new environmental threats, new financial instruments that Congress had not yet imagined when it wrote the underlying statute a generation earlier. What this ruling does is tighten that arrangement considerably. It says, in effect, that the deference courts have historically shown to agencies has limits, and that those limits are now going to be enforced more rigorously than they were before. Legal analysts and scholars, quoted in reporting from multiple major news organizations, have described this as a generational shift in the relationship between the federal courts and the executive branch. The Economic Policy Institute, the Brookings Institution, and legal minds across the ideological spectrum have noted that the practical consequences will take years to fully materialize, but that the direction of travel is unmistakably clear. And here is where the numbers begin to tell the story most clearly. A significant share of active federal regulations, and we are talking about thousands of rules that govern everything from the air you breathe to the interest rate on your mortgage, to the safety standards on the equipment that goes into your child's school, rest at least in part on delegated authority from Congress that was never spelled out with the specificity this court now appears to require. That does not mean all of those rules fall overnight. Courts do not work that way, and legal change rarely arrives all at once. But it does mean that every one of those rules is now potentially vulnerable to a legal challenge that has a meaningfully better chance of succeeding than it did last month. That is a consequential change in the legal landscape. Whatever your political persuasion, let me put my analyst hat on for a minute, because the strategy behind this case is worth examining carefully. The people who brought this litigation knew exactly what they were doing. This was not a spontaneous legal dispute, two parties stumbling into a courtroom with a genuine disagreement. This was a carefully selected vehicle for a legal argument that has been developed and refined over years by a network of legal organizations with deep resources and patient long-term strategic thinking. They did not pick this case by accident. They selected it because the underlying facts were favorable. The circuit in which they filed had a composition likely to receive their arguments sympathetically. And the question the case raised could be framed in a way that would give the justices who share their judicial philosophy the opening they needed to write the kind of broad opinion that reshapes the landscape. That is sophisticated legal strategy. I will give credit where credit is due. The orchestration here was professional and deliberate, and it worked. And understanding that it was orchestrated helps you understand what comes next, because this is not the end of a campaign. It is one successful battle in a longer war that has many more engagements planned. Now ask yourself this honest question. Who actually benefits when federal agencies lose the flexibility to regulate broadly and respond quickly to new problems? Because that is always the right question to ask in Washington. Follow the incentives and the strategy reveals itself. The industries that have spent years chafing under federal regulation are the obvious and immediate beneficiaries. Some of those industries are ones most Americans would recognize as legitimate players in the economy: manufacturers, energy producers, financial institutions who have genuine and sometimes reasonable complaints about regulatory overreach and compliance costs that can fall hardest on smaller competitors who lack the legal departments to navigate complex rules. Those are real concerns, and any honest analysis has to acknowledge them. But some of the interests cheering loudest for this ruling